Hello, everyone, and welcome to Uncivil Law. And for today's story, we have a story where a trial judge went off the rails and prejudiced a result to the point where someone's $13 million award has to be set aside. This is a wonderful story because the judge went just so far. This is from the State of California Court of Appeals. This is a court of appeal in California, Second Appellate Division, Division number 8 in the state of California, Los Angeles County. This is a case of Lauren Pinter Brown versus the University of California. In this case, the plaintiff alleged discrimination and that they were discriminated on the basis of protected classes. And then they won. They won. But unfortunately, the way they won was not so great because the trial judge decided to stoke the jury a little bit, decided to kind of suggest what the results will be. You'll see what happened. The trial judge said some things. Let's discuss what the trial judge said. Let's get started with this. On June the 22nd, 2016, Dr. Pinter Brown filed a complaint against the university, alleging discrimination on the basis of gender in violation of law, harassment on the basis of gender in violation of law, retaliation for complaints of discrimination and harassment in violation of law, discrimination on the basis of age, harassment on the basis of age, violation of labor code, violation of the Equal Pay Act, and intentional infliction of emotional distress and defamation. So, yeah, basically we are alleging that we were discriminated on the basis of our sex or on the basis of our age. We are fired or otherwise reprimanded, and we complain about it, and then we're reprimanded for that and other things. So we're suing under state law, but this is also reflected in federal law. So we could be suing under federal law, but we're suing under state law claims. So yeah, we were discriminated against. All right, so that's fine. We know how to do those kind of claims, and the trial court knows how to do those kind of claims, right? Let's get started. Dr. Pinter Brown proceeded on two theories. She argues she was subject to adverse employment action and or constructively discharged. So she was fired in fact, if not in by word. Under both these theories, she's required to prove she was employed by the university, her gender was a substantial motivating factor for the reasons of her discharge, and or the adverse action, she was harmed, and the university's conduct was a substantial factor in causing harm. To prove she was subject to adverse employment, Dr. Pinter Brown had to prove LCLU took action or engaged in a course of pattern of conduct that, taken as a whole, materially and adversely affected the terms of her employment. To prove a constructive discharge, I was fired without being fired, Dr. Pinter Brown had to prove UCLA, through its officers and other people, intentionally created or knowingly permitted an environment so intolerable a reasonable person would have no reasonable alternative except to resign. So these are our theories. What does the district court have to do? Okay, so this is where the district court gets involved, right? We know the theory of the case. We know what's going on. Now, the district court is supposed to act as a neutral arbiter. They're not supposed to favor one result or another. But the district court said some things before the trial began to the jury as they were being seated. They said some things that may suggest, the trial court may be suggesting which one of the parties they want to win. So we have a case where a person is suing on the basis of discrimination and a person saying no discrimination occurred. And the trial court may have said some things that could potentially suggest that they wanted a particular outcome to occur. So what things did they say that might have suggested they want a jury to come to a particular conclusion? What did the court say as the jury was being seated? Well, here's what the court said. Let's read. As the prospective jurors are being seated, the trial court stated the following. The arc of the moral universe is long. Dr. Martin Luther King said these words in 1965. The arc of the moral universe is long, but it bends towards justice. The court welcomed the jury by saying, if you are selected as a juror in this case, your job will be to help bend that arc towards justice. He then told the jurors Martin Luther King stood on the steps of Lincoln Memorial in 1963 and gave his famous I Have a Dream speech. In there, the court continued. He spoke of his dream, that someday we would live in a society where people are judged by the content of their character and not by the color of the skin. The court then proceeded to play a video, not part of the record, and continued to give the prospective jurors a presentation about various noted civil rights leaders standing up for justice throughout history. The court discussed segregation, people being denied the right to vote, and tens of thousands of people who demonstrated for equal rights for African Americans in the march from Selma to Montgomery during the Civil Rights Movement. The court discussed Rosa Parks and her arrest and conviction for sitting in front of the bus, which led to a widespread community protest. The court talked about Elizabeth James, who refused to disembark a trolley in New York City in 1854 after the driver told her to wait for a car for non-white people. The court told the jury about Susan B. Anthony, who voted in a national election before a woman won the right to vote, was arrested, and then acquitted in order to pay a $100 fine. The court mentioned the first woman elected to Congress, Jeannette Rankin, and the first demonstration in front of the White House for women's suffrage. Finally, in 1920, the next year, the court continued, Congress passed the 19th Amendment. It was ratified by the states as women gained the right to vote. That arc is long, and it bends towards justice. The court then told the jury about the Japanese internment camps during World War II and about Fred Korematsu, convicted of resisting this internment. The court told the jury about Dolores Huta and Cesar Chavez, who the court stated appeared directly in this court many times and brought attention to the plight of the poorest of the poor here in California, the Mexican-American and Filipino-American farm workers who were denied their basic rights under law. The court told the jury about Harvey Milk, the first openly gay public official in the United States, and his assassination by a member of the San Francisco Board of Supervisors. He didn't get to see that just 2.5 years ago, our Supreme Court ruled discrimination against gay and lesbians was unconstitutional. That gay and lesbians, like everyone else, had the right to marry and the right to raise a family. The judge told the jury he was honored to sit before people who are going to continue to bend that arc. The court then clarified, now why do I talk to you about Dr. King and bending the arc? Is the plaintiff in this case a Dr. King or Rosa Parks or Elizabeth Jennings? No. Is the defendant in this case a Dr. Jennings or Susan B. Anthony or Cesar Chavez? No. But you, the juries in this case, are going to become Dr. King. You are going to become Dr. King. Wow. It is your job to help bend that arc towards justice by rendering a verdict based on the law and the evidence you're going to be hearing about in this case. But wait, there's more. The court then concluded its presentation by reciting a passage from Harper Lee's To Kill a Mockingbird, in which the attorney Atticus Finch tells the jury, a court is only as sound as its jury, and a jury is only as sound as the men and women who make it up. The court then swore in the jury. Okay, yeah, I think the court may have been suggesting which of the two sides in this case should win it. Should it be the person who was claiming discrimination or the person who was saying no, there was no discrimination? Which of these two sides would win? Do you think any of these statements might influence a jury to go one way or another? As we're about to swear in the jury, we're telling them all these fantastic jails, and then we're telling the jury, you are now Martin Luther King. Bend the arc towards justice, my friend. Bend the arc towards justice. Wow. That's truly amazing, man. So after the break, UCLA requested a mistrial, because why would they want a mistrial? Because surely they can get justice, right? No, not so much. At least UCLA doesn't think so. UCLA said the court's presentation lauded this country's struggle with discrimination on the basis of numerous protected classes, including gender, through highlighting the individuals who stood up for themselves. And this presentation created a great risk that jurors would be preconditioned. So UCLA is not having any of this. The court denied the motion for a mistrial. The court sees no problem with any of this. The judge states he gives this presentation before all trials in this courtroom. Apparently, this is a thing he does routinely. And he says, quote, sometimes justice is done by jurors ruling on behalf of the plaintiff, and sometimes justice is done by jurors ruling on behalf of defendants. The judge stated his presentation was a correct statement of the law, and he did not believe that it was a prejudice to the jury. So he saw no problem with any of these statements, which apparently is routine. And he said, no, a jury wouldn't be influenced to decide this case for one rule or another, having told you about all these great civil rights heroes who fought for the oppressed, and that you now are MLK. You are now the embodiment of MLK, and continue bending the arc. No, that's not suggestive in any way. I don't know what you're talking about. Wow. Amazing. So you might want to know what the standards that apply to trial judges are. Not that you really need to be told, because you probably don't need to be told what the standards are to know this is a violation of it. This is one of the times when I probably don't need to really educate you about the law, because you can probably figure out the result without me telling you. But just for the sake of completeness and for the sake of me being a good legal educator, I'm going to tell you the standards anyway. So now you can make a decision based on the standards that actually apply. So what are the standards? Here they are. Trial judges should be exceedingly discreet in what they say or do in the presence of the jury, lest they seem to lean towards or lend their influence to one side or another. A judge's conduct must accord with recognized principles of decorum, consistent with the presentation of a case in an atmosphere of fairness and impartiality, and the trial of a case should not only be fair in fact, but should also appear to be fair. Yes, justice must be done and seen to be done, yeah. Jurors rely with great confidence on fairness of judges and upon the correctness of the views of judges expressed during trials. For this reason, too strong an emphasis cannot be laid on the admonition that a judge should be careful not to throw the weight of his position into the case, either for or against either side. Yeah, you're just supposed to be a neutral arbitrator. You're not supposed to favor anyone. The Court of Appeals says the trial court's remarks to juror violate these principles. Yeah, no joke. It is a little bit prejudicial. It gave the appearance the court was partial to Dr. Pinter Brown's causes of action. The court framed this case as part of a centuries-long fight against discrimination and inequality. The court not only invoked the words of Dr. Martin Luther King, one of our nation's most respected and revered leaders, it also quoted one of the most well-known lines from the famous venerated I Have a Dream speech. At the apogee of the civil rights movement, Dr. King told the world that the arc of the moral universe bends towards justice. Here the judge told the jury it was their job to be Dr. King and help bend the arc. That might be a bit suggestive, yes. When ACLU objected to this lengthy recitation of our country's history of fighting discrimination and description of the heroism of the individuals who led those efforts, the court insisted its presentation was not improper or prejudicial because those jurors were told that those that lauded civil rights were sometimes plaintiffs and sometimes defendants. We're not persuaded. Regardless of whether Rosa Parks, Elizabeth Jennings, Delora Huta, or any other of these icons highlighted in the message were plaintiffs or defendants, the message is clear. Each of them is fighting to right the grave and wrong history of discrimination. By telling the jurors that they themselves are, in fact, Dr. King, the court told them that they are also there to right a wrong. A wrong has occurred. Each case cited by the court was another step in that direction, and in the right direction, towards equality and away from discrimination. The court's message is clear. The jurors' job was to continue that great, noble, and moral tradition of pushing society towards equality. Yeah, no, fortunately, the social justice warriors have not yet gained control of the courts. And, with the amount of appointments that Trump has put into the courts, because like a quarter of the bench is now appointed by Trump or something, hopefully they will not gain control of the bench anytime soon. Because, we actually are supposed to do law in the law world. We're not supposed to bend things to one side or another. We adjudicate things on the fact. Was this woman discriminated against or not? I have absolutely no clue, one way or another. Whatever is just should be done. But, this does kind of suggest that what the just outcome is before you ever start. A little bit. Yes, good times. The remarks of the trial court here were not an impartial call to duty, you don't say. They were a resolute and stirring call to action which stacked the deck against UCLA. You think? It was grave error for the court to begin a gender discrimination trial with a presentation highlighting the great accomplishments and achievements of our nation's civil rights leaders that have they made towards creating the world to be free of discrimination and telling prospective jurors they are there to carry out this quest. Yeah, no. Although particularly prejudicial in a discrimination case, we believe these court's comments and call to action are inappropriate in all the cases. All the cases. So that is a note to the judge. So to the extent you are in fact doing this in other cases, which is what you said incidentally, it's particularly grievous here, but it's inappropriate in all the cases. All of them. It's a little bit prejudicial. It's a little bit stacking the deck. Please stop doing this in just all the cases. That would be great. You as a judge are not supposed to care who wins. You're decidedly supposed to not care who wins. Your job is to be a neutral arbiter and neutral referee and to make sure each side is treated fairly. And, this speech is not doing those things, so you need to stop. Yeah. But, of course, this case wouldn't be complete if it was just the prejudicial comments before the case started. That was bad. But do you think this case stopped there? Of course it didn't. There were also things that happened during the trial that we might want to talk about. Specifically, evidence that was included that perhaps not so much. You shouldn't include that evidence because it's not really valid. So let's talk about the things that were included at trial. Not that we stacked the deck from the beginning, but we have to keep stacking the deck as the hand is unfolding. So yeah, this is the poker equivalent of stacking the deck before the hand is drawn, and also continuing to stack the deck as you go. So let's talk about the stacking the deck in the middle of the hand. That's good. Let's get started with that. Throughout the trial, the court allowed the doctor to present the jury with unrelated claims of discrimination at UCLA. So we're talking about things outside of what happened here. First, it allowed Dr. Pinter Brown to introduce evidence through witnesses of a report detailing findings of a 2012 investigation into incidents of racial discrimination at UCLA. This type of evidence that an employer waged the same type of discrimination against other employees as it did against the plaintiff, is sometimes called Me Too evidence. As discussed below, Me Too evidence can only be admissible to prove intent and motive with respect to protected class. Additionally, the admissibility of this evidence hinges on how closely the evidence related is to the circumstances. Me Too evidence is never admissible to prove propensity. Yes, that's exactly what court allowed. Yeah. So these kinds of evidence is not allowed in either a civil case or a criminal case. You're allowed it for some reasons and not other reasons. And you're not allowed to show propensity. In other words, you're not allowed to introduce it that because you did all these other bad things in the past, you did this bad thing now. You're not allowed to do that. You're allowed to show as to motive. You're allowed to show it as to the intent. So you can, like if it's ambiguous, you can use it to show, well, other things happen, therefore this goes to show their intent or motive. But you can't just bring it in for any reason. You're not allowed to argue propensity. You're not allowed to argue, you did all these other bad things, therefore you did this bad thing. No. You can show what your motive is or your intent is, but not for propensity. And you brought it in specifically for the reason you're not allowed to do that. So you're not allowed to bring in prior bad acts, and say, well, they're a bad person. You're supposed to punish someone or not for what they did in this case. What they did in other cases, they might be punishable for or not, but you have to bring those cases. You can't punish them now for what they did in the past. That's not how, or at least you can't find them liable for what they did in the past, to be more proper. Like when it comes to sentencing or the determination of liability, you might be able to factor it in there. So you might be able to bring it in for sentencing or the amount of the award, as it were. But you can't bring it in for underlying liability. So you can't do that. There is no question the court allowed Dr. Pinter Brown to use the report to paint ACLU as a hotbed of discrimination and harassment. During closing arguments, Dr. Pinter Brown quoted exactly what Justice Carlos Moreno stated in his 34-page conclusion. We don't investigate, we don't educate, we don't take seriously anti-discrimination laws here. And in fact, when we're dealing with a professor or someone who brings in a lot of money to UCLA, we as practice sweep it under the rug. That is what an independent investigation into discrimination, bias, and retaliation at UCLA concluded. Dr. Pinter Brown described the report as the very blueprint of what goes on and what has gone on by neutral as phrased by an independent investigation. Dr. Pinter Brown described the report as condemning how they operate with regard to this particular issue. That's a little bit suggestive, yes. Where mistakes on the part of the trial court abound and touch not only the charge to the jury, which is the reading of the law, but also rulings on evidence, what can be considered by the jury factual. So charges of the jury are the law. Rulings on evidence are the facts, right? It cannot be assumed the defendant has had a fair trial and no miscarriage of justice is done. Yeah. So when we have a whole bunch of errors that go to the facts or to the law, or in this case both, we can't think that justice has been done. The errors in this case were cumulative. The court's charge to the jury was that they stand in the shoes of Dr. King and bend the arc of the moral universe itself, which is wow, towards a free future that is free of discrimination. Allowing the contents and conclusions of a report detailing racial discrimination authored by a retired Supreme Court justice to be used as propensity evidence, which no, you can't do that, to show UCLA's medical school discriminated against Dr. Pinter Brown on the basis of gender. Allowing a jury to view and hear testimony about a long list of anonymous, unadjudicated complaints not properly connected to this case, and resurrecting after the close of evidence a retaliation claim previously adjudicated. So they had normally said, they had once said, no, you can't do that, and then said, oh yeah, you can present it to the jury. So that's great. Good job. Based on the totality of circumstances, we cannot conclude the cumulative errors here were harmless. No, it's a little bit more than harmless, yeah. The court's error constituted a miscarriage of justice and created an atmosphere in which UCLA did not receive a fair trial. Accordingly, we reversed the judgment and the award because it's all bogus. So that is the end of our coverage of the case of Lauren Pinter Brown versus California. So I don't know what UCLA did or did not do to Dr. Pinter Brown. I don't know what happened, but I do know the judge went way off the rails, all the way off the rails. The rails are no longer seeable. Are there rails? Were there ever rails? Who knows at this point, because that's how far gone we are. The judge somewhat stacked the deck a little bit as it was swearing the jury in, and then also allowed evidence in for propensity evidence, which is specifically not allowed to do. So of course she won at trial, but no, not so much. ACLU got a bum rap. So we have to go back and start this whole thing all over again and try to figure out whether or not UCLA did a bad thing. So as to whether or not UCLA did a bad thing or not, well, that's going to have to wait for another day. But at least for the moment, that's the end of the coverage of this case. Thank you for joining me as we both read this case together and now better understand the law. If you're enjoying this legal education content, please subscribe to this channel. It really helps us grow. And check out one of our other videos, including the one that's currently being displayed on the thumbnail on screen. Thank you so much for your continued support. And until later, my friends, cheers and goodbye.